Showing on this episode of Law Weekly, a conversation about the constitutionality of the laws establishing the Economic and Financial Crimes Commission, EFCC, and the suits by 16 state governments challenging same. And as part of agenda setting, we also have some senior lawyers speak about some of the reforms the judiciary urgently needs, plus a recap of the top trending stories in the news. Hello and welcome to the program. I'm Shola Shuyele. And it does feel good to be back on your screens after a month-long vacation. A 7-man panel of justices led by Justice Wani Abaje has fixed October 22 to hear the suit of 16 states challenging the legitimacy of the Anti-Graft Commission, the EFCC. In this interview with Senior Advocate of Nigeria, Adeyinka Olumide Fushika, I began by asking his views about the suit and whether there's any difference in this recent suit and others decided in the past by the Apex Court on the legality of the EFCC.
Well, we have to be careful here. And the reason why I have to be careful is because the case is live. No decision has been made yet on it. It's before the Supreme Court. So we have to wait for the Supreme Court to make a decision on it. The argument, the way I see it is, or the sense I make of it, is that the EFCC Act is based on a UN convention, and that before that can be domesticated into an act here in Nigeria, the law says that it cannot be done alone by the federal government of Nigeria. It needs the support of the state houses of assembly, and this wasn't done. But the EFCC Act is how many years old now? So why are they just realizing? But the Supreme Court will determine it. Don't forget, if you go into the history, I remember that the ICPC Act, for instance, was challenged by the then Ondo State government against the Attorney General of the Federation and the other states. They participated in it. The EFCC Act was challenged in another case, Abia State government, I think, against the Attorney General of the Federation and all the other state governments. They made all sorts of arguments. They've not succeeded till date. And they have a novel argument now. That's just the difference between those old cases and the new one. The novel argument here now is that, well, the federal government ought to have consulted with the states, the State House of Assembly, the States House of Assemblies ought to have, it should have been laid before them, and they should have also adopted before it is now made into an act of the National Assembly. That's the novelty of the argument in this case. And, well, as I said, it's before the Supreme Court. We'll see how that turns out.
What about the arguments by the states that issues of corruption is on the concurrent list, and some of the states have their own anti-corruption bodies, so the EFCC cannot be solely responsible for determining prosecution? The
law is very clear too that I don't buy that argument anyway, because if it's concurrent, it means if both of us have concurrent powers, you can do it, I can do it. You cannot say because you can do it, I'm restrained.
And I'm already doing it.
Okay, let's put it this way. The police can investigate crimes, certain crimes. EFCC can investigate certain crimes. DSS can investigate can the police restrain the EFCC from doing its own work? Can the EFCC restrain the DSS? Everybody must start within it. So if the argument is that we have also set up our own anti-corruption agency and they have the power to look into these things, it only means that you have a right to do it. So if you feel that you want to, charge anybody under your own law, you are free to do so. You cannot say, I don't have the power to charge. So it only means that we don't both have the powers. If the two go to court, and for instance, a person has been charged under the state law or the state anti-corruption, whatever, and he has been discharged, and then the EFCC wants to do the same thing, you can say, well, it's going to suffer double jeopardy because it's already been tried by, no matter how organized, just to quickly rush to court and say, well, are you guilty or not guilty? I'm not guilty. And before the state high court, and the state high court says you are not guilty, which is a very serious problem we are having in this country, with the judiciary has to, but it's not the subject of this discussion. So it is because of that lack of faith, suspicion, and all that. That is why, for instance, the state will say, oh, no, I want to have my own anti-corruption agency. It's a lie, really. Let's ask ourselves, since 1999, give me an example of a state that has taken any state official, charge any state official for any act of corruption. You won't find any, but I'm not aware of any. You understand? So it's only at the federal level that you still have semblance. There's abuse, there's political vendetta, and so on and so forth. But EFCC still charges federal government officials, ministers. He may say, okay, the current regime is after his opponents and all that, and so on and so forth. He's not going to, bring anyone that is serving this current government to book or to charge them and so on. Possibly.
And like you've alluded to, one of the motivations for this case is the accusation that the EFCC is a political tool in the hands of the federal government to harass states. And the other is that the anti-graft agency is taking over the functions of the state houses of assembly.
No, the state houses of assembly are to make laws for their state. They are not to prosecute anybody. It's just a legislative arm. So how can the EFCC or ICPC take over their functions? I think that's just an exaggeration. What they are saying is that leave us to continue to wallow in corruption. It's our money. We don't want the federal government to be, after all, it's our money. But when you look at it, it is only when it comes to things like that, they suddenly realize that, most of these state governors, unfortunately, but at the end of the month, they will queue in Abuja to take allocation. It's not federal. You gather the thing and say, okay, you take this, you take that. And then when you have it, you are not saying at that state that, no, this is a federation. I don't want the federal allocation. I'm satisfied with the money I'm making from my own states and so on and so forth. So keep your federal, you go and queue, you take the money. That time you won't realize that you needed a convention to ratify a convention and all that. After taking the money, you use it to send your children to school. You use it to buy gas, cooking gas, fund your girlfriend, buy a recharge card. I'm saying this thing because these are things I've seen. You take government money, put it in whatever and begin to spend it anyhow. You turn the resources of the state, the treasury of the state into your personal treasury. And when you are called upon to account for it or say, why are you doing this? Come and explain. You will now remember that this is a federation. What I'm saying is that it is as a public commentator, is a politically motivated suit. It's not meant to achieve anything good for Nigeria or for the hapless citizens of Nigeria who are suffering the effect of corruption and so on and so forth in this country. So let's see what the Supreme Court would come up with on this issue.
Let's talk about the EFCC itself and the way that it does its work. It has come under severe criticism following allegations of corruption and shoddy investigation and prosecution. Now, I know that you've defended a lot of cases against the EFCC, and in recent times, I was even surprised to read that you are prosecuting some cases for the agency. So you've been on both sides of the divide. What do you think about the way that the commission does its work?
To the credit of the current leadership of the EFCC, what is done is to go expand the coast, so to say, look, we want people can do prosecution for us and so on and so forth, not restricting it to look for people they believe. Maybe they've done their investigation and all that, and they feel, okay, this person. So you'll see that quite a number of new people are. But what I'm saying is that in terms of how do you rank the current leader, the fact that they are not looking, I'm supposed to be their, I don't know what their enemy, so to say, if they want to classify, he's defending cases against us, therefore, it must be. But they've seen the record that, if I defend against you, it is because your cases were some people, not the institution. Some people within the institution, Nigerians are prone to abuse, and you'll see that most of them, I don't want to brag, they know that I had good reasons to take up those cases against them, just to show to them that you are wrong. Yeah, you cannot be using. Some people within your organization cannot be. It's so unfortunate, In those days, it used to be a single building, one-story building in Abuja, and that office in Lagos here with Ribadu, So it was a small organization. So when I say it has become a Nigerian organization, what do I mean? If you go to Abuja now, it's an edifice, and they have offices all over Nigeria. I think it is a mistake. Yeah, I personally believe that was a mistake on the part of the EFCC. They should have stayed small, stayed focused on, you are not the Nigerian police force. There's Nigerian police force to tackle. That's the primary responsibility of. So you are an interventionist agency to focus on specific area of the law. So I think that they should have stayed there small and not expand this much. And I think it is that growth that has led to rot. Let me put it that way. I want to be very, very careful. There are a lot of people in the EFCC that are slaving night and day to make this country better, to fight, to actually, deliver on the job. But what I mean by it's a Nigerian institution is that there are also, those that are not, they don't have the same level of commitment to the task. And you find situations, for instance, where like I said, if you recruit and they don't have jobs, they will begin to canvass for jobs now. And I had the opportunity of telling the chairman that on one occasion, that all this, you have convicted 2,000 people. Go and check. Somebody wrote a letter to one girl or one woman in America saying, I will marry you. Come and, and then it takes, maybe deceive that person to take $50 or $5,000 and all that. That's, and then you add everything together. Yeah? All those, it's not up to 1% of one government official has stolen. You understand? So as you are pursuing that, if you feel that it's material to go after those ones and so on and so forth.
Can leave the bigger price.
I think that, I suggested to him that, why don't you leave that to the police? We still have a police force in Nigeria. What's their responsibility? Leave that to the police and focus on don't overstretch yourself. You don't have the capacity. Concentrate on the ones that would have major impact on the country. Take the Nwude case, for instance. That was massive.
The one against the Brazilian bank.
Yeah, that was,
led to the collapse of a bank in Brazil.
That was massive. That was thorough investigation because you concentrated on it. And I think that the current leadership is, constricted in that.
Do you agree with some of your colleagues and some people who say that perhaps the EFCC will record more wins if we have special courts, designated courts to handle financial crimes?
Look, let me tell you, it's not not because I'm not indicting. People are overwhelmed. Go to the Court of Appeal in Lagos. That's Court of Appeal. The last time I went there, I met the staff working in darkness. Darkness. No light. Because the cost of diesel has become so prohibitive now that their budget can no longer, carry it. They've done inverter, done all whatever, but there's a limit to what that. So the environment will suddenly change. The human beings, I think, okay, I was just reading something before you came. Maybe I should. Chief Obafemi Awolowo, Babangida set up this political bureau thing, to collate views and so on. So the late Chief Obafemi Awolowo was invited to participate, and in his letter, I will just cut it short. He said, at the end of the day, when we imagine that the new order is here, we will be terribly disappointed. In other words, at the threshold of our new social order, we will see for ourselves that as long as Nigerians remain what they are, nothing clean, principled, ethical, and idealistic can work with them. And Nigerians will remain what they are, unless the evils which now dominate their hearts at all levels and in all sectors of our political, business, and governmental activities are exorcised. But I venture to assert that they will not be exorcised. And indeed, they will be firmly entrenched unless God himself imbues a vast majority of us with a revolutionary change of attitude to life and politics, or unless the dialectic process, which have been at work for some 20 years now, by force, make us perceive the abominable filth that abounds in our society, to the end that an inexorable abhorrence of it will be quickened in our hearts and impel us to make drastic changes for the better. There is, of course, an alternative option to us: to succumb to permanent social instability and chaos. On the premises, I beg to decline your invitation. I'm yours truly. I just hope that something will give, so that critical elements in society, those who are privileged, because if you're a lawyer, you're a privileged person in this society, who are privileged. If you are working in EFCC, out of, what's the population of EFCC? Out of 200 million Nigerians, you have the opportunity to be employed in such an organization. If you are a counselor, you know that you are privileged, because there are so many people that can be a counselor, but you are privileged. You are put in a privileged position. When you realize that this is a privilege that I have, let me serve my country well. Let me do it well until we have that critical mass. We are just deceiving ourselves.
And from that interview, we move on to another very topical issue. Against the background of the recent appointment of a substantive CJN and the motion by lawmakers for the Constitution Review Committees to organize public hearings to address permanently the issues of delays in the courts, I spoke to some senior legal practitioners about how the leadership of the judiciary can tackle this and restore confidence in that sector.
Naturally, lawyers we tend to be technical. It is part of our approach to work. Even though it has been resounded that the court should be paying attention to substantial justice other than technical justice, but oftentimes when lawyers hang it on the part of jurisdiction, the court is bound to hear them out. So such applications will then slow down the natural flow of the matter, and the court must hear them out. So if lawyers should now consider the opportunity of either handling whatever technical issues that arises in their matter at the end of the matter, then it can help to give the judges the opportunity to hear everything at once, and the argument will be taken at the stage of final written address. We've learned and heard over and over that in foreign jurisdictions, there are steps that if a lawyer takes while handling a matter, and if the judge finds it unreasonable, the court on its own will penalize the lawyer. If practices like this could be imbibed in our own system, it will help to put caution on all sides.
The first issue on how matters can be expeditiously disposed and dispensed with would be for the office of the CJ to do what I will call a data density check. Right, data density check will mean that there are some areas in Nigeria that you have that has more commercial transactions, that has more people, has more litigation. Right, in those areas, if you do what I would call data density check, you're able to know the commercialization of the area and the quest for litigation and court matters in those areas. Then when you ascertain that, what are you supposed to do? You are to create, decisions should create more courts, of course appoint more justices, right? As a practicing lawyer, we check the court list at times. You see that a judge is handling about 30 30 to 40 cases is incredible. 30 to 40 cases every day. Now, the ripple effect of that will trickle down to a judge getting burnt out. A judge can actually be tired because, my lord, the court, it's still a human being. There's a human face to it.
It depends on, 1, the kind of case, 2, the kind of judge, 3, and the kind of lawyer. Now, some lawyers, they are only interested, with due respect, in coming to take appearance fee. I remember a case before Professor Justice Obiazo. I came for a matter. I saw a defendant crying, and I decided to do the matter pro bono. When the matter was discharged, the case was struck out, and the defendant was removed from prison. The lawyer came fighting with me, who asked me to take the matter. He has missed his appearance fee. So some of our colleagues, with due respect, it is that appearance fee. That is 1. 2, frivolous matters that could be settled. That is why this idea of Lagos State insisting on pre-action protocols of attempt at settlement. It's just that some of our lawyers just make it look like a mere formalities, no attempt to settle. So, so it depends on the lawyer. Then there are some cases on the day the matter comes up, it can be hard. I also want to refer to Professor Justice Obiazo, where we took a matter on a day. The next day he gave judgment. I don't know if there's any other matter that has been handled so fast in the history of litigation in Nigeria. So you see, it depends on the judge. He could have adjourned for another date for judgment, but he looked at the case and he feels this is something he can give judgment on. It's only a few of our judges, with due respect, that read their files before coming to court. If you read your file before coming to court, you will know the matter you can dispense with. You will not allow any lawyer to bamboozle you.
And just before we go, here's a quick recap of some of the top stories we're tracking at the court.
We begin with the report that the Supreme Court has fixed October 22nd to hear a suit filed by 16 state governments challenging the legality of the Economic and Financial Crimes Commission. The suit, which was instituted by the Kogi state government and 15 other states, is contesting the constitutionality of the laws establishing the EFCC and the Nigerian Financial Intelligence Unit. A 7-man panel of justices, led by Justice Uwani Abba Aji on Tuesday, fixed the date for hearing after the states were joined as co-plaintiffs and leave was granted for consolidation of the case in the suit originally filed by the Kogi state government through its Attorney General. All 16 states in their reliefs contended that the Constitution is the supreme law and any law that is inconsistent with it is nullity. Away from the Supreme Court, the Chief Judge of the Federal High Court, Justice John Shaw, has rejected the request by the detained leader of the indigenous people of Biafra, Nnamdi Kanu, for Justice Binta Nyako to recuse herself from his case. Justice Shaw returned Nnamdi Kanu's case file to her to handle, saying 2 other judges were previously recused from the case. Justice Shaw stated that Kanu's case was reassigned to Justice Nyako due to its prolonged nature, which was as far back as 2015. Since she had handled the case for the most part, she was deemed the most suitable judge to see it through to its conclusion. However, the Chief Judge directed that if at the next hearing of the case, Kanu still insists on recusing Justice Nyako, he must file a written motion on notice with an affidavit stating all the grounds for requesting the recusal. Mr. Kanu must also serve same on the prosecution team and appear before Justice Nyako for her review and determination, after which she can make her decision. Justice Nyako had earlier recused herself from the case following an oral application by Kanu and his lawyer, Aloy Ejimako. He had expressed his displeasure and loss of confidence in Justice Nyako, accusing her of disregarding Supreme Court orders. Staying at the same court, another judge of the FCT High Court has summoned the former governor of Kogi State, Yahaya Bello, over allegations of criminal breach of trust. The summons orders the former governor to appear before it on November 14. The summons, which was issued by Justice Marian Anini, reads in part, "You are hereby summoned to appear before the Federal Capital Territory High Court of Justice, High Court Number 3, sitting at Maitama on the 14th day of November 2024 at the hour of 9 a.m. to answer said complaint." According to the summons, Yahaya Bello is accused of violating Section 311 of the Penal Code Law Cap 89 laws of Northern Nigeria 1963, which deals with criminal breach of trust and is punishable under Section 312. Through its counsel, Senior Advocate of Nigeria, Kemi Finero, the EFCC had applied for a bench warrant to compel the appearance of the former governor in court with respect to an alleged 80.2 billion naira fraud. In Lagos, Justice Deyinde Dikpeolu of the Federal High Court in Lagos has fixed November 1, 2024 to rule on the application by the Economic and Financial Crimes Commission for final forfeiture of the sum of $2.045 million, 7 choice landed properties and shares involving former Governor of the Central Bank of Nigeria, Godwin Emefiele. The court will also rule on the formal application filed by the former banker for a stay of proceedings. On August 15, 2024, the court had authorized the EFCC to temporarily take custody of the assets. In granting the application, the court had directed the EFCC to publish the order of interim forfeiture for any person interested in the funds to show the cause why it should not be finally forfeited to the federal government. At the resumed hearing on Friday, Rotimi Oyedepo-Osan, counsel for the EFCC, moved an application for the final forfeiture of the sum of $2.045 million, as well as share certificates, which he said was not contested by the interested party. In opposition, Mr. Olalekun Ojo, counsel to the interested party Emefiele, urged the court to hold that the interested party has shown in a balance of probability that court ought not to grant the final forfeiture of the properties. He adopted his written address and urged the courts to refuse the application.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I am Shola Shele. Thank you for watching and see you next week.